Today we're talking about Fe1 EU Law, and yeah, we're going to go down through the autumn 2023 paper. With the paper, let's just get into it. So question 1, if we go down to the bottom, it says referring to relevant CJEU case law on treaty obligations of member states to transpose union directives and on the capacity for direct effect. So we know that this is a question on direct effect of such directives. Throughout your answer, advise the Irish Worker Solidarity Association on this point. So then I guess the question is whether all of this, I'm not going to read down through it, would this directive be capable of direct effect? And then, of course, we need to apply the law to that. So, Reiner's Van Ganden lose, and then the conditions around that. So, is it clear and unambiguous? It is unconditional. There's no room for discretion when it is implemented, and has the time limit for implementation passed? They're all the kind of things you will be looking for. The other kind of question that usually comes out of the transposition of EU directives into law is the group or the claimant bringing the case. Here it's the Irish Work Solidarity Association. Can they rely on it against the state? And then we have obviously a vertical direct effect and horizontal direct effect, and whether that group is an emanation of the state, and then you apply the case law in Facchini Dori, Foster v British Gas, and Marshall. So it's a very straightforward question. It gets asked a lot, and yeah, I would have said there was no real issue there for most people to pass that question. So the second question was an essay question, and we see Commission v Hungary. So we know that this is as regards the Charter. And when we say Charter, we mean of fundamental rights. Now, this would actually be a question I would not answer myself, simply because I'm not really that interested in this area of law. But anyway, this is around Article 17 of the Charter of Fundamental Rights, and then you're asked to discuss how the CJU in that case law, so you'd have to know the case since the Charter was declared in December 2000, but especially since it came into force on the 1st of December 2009, which is the Lisbon Treaty coming into force date, has allowed provisions of the Charter to be used to challenge a wide range of EU national legislative measures in the manner described in Commission v Hungary. So like even in Irish law, the Charter is used a lot, for example, when it comes to privacy in Irish constitutional law. So like there's literally a lot you could discuss there. It's just, I would say it would be around the jurisprudence and the acceptance, because the Charter has now become part of EU law, all of the jurisprudence that comes with that, and then the kind of guaranteeing of those fundamental rights. Yeah, I would not have answered that question, to be honest, myself. Question 3, then, if we scroll down the question, it's an essay question, and it basically asks, with reference to the TU and TFEU provisions and pertinent case law, the roles of each, the Parliament, Commission and Council in establishing, amending legislative, delegated and implementing acts. Very, very easy. I have a whole chapter on that, around the legislative process, the articles that relate to each of those bodies. And that really would have been a question that most people should have been able to pass if you had covered the organs of the EU in the ebook. I really do think in general EU is an easy one to pass. I hope that doesn't come back to bite me, but like as I was saying the other night to the ladies or the uh, women in law committee in University of Galway, I've never seen anybody fail EU, to be honest. Very straightforward exam, and the exam is always, you know, copy and paste of what went before it. So yeah, it doesn't really bring to me a lot of, like, you know, worry and anxiety in the same way, for example, constitutional does, just because sometimes the way the constitutional law exam is written, it can be quite confusing, a little bit like contract as well. Anyway, so question 4, if you scroll down to the end, it says, advise Paolo about whether EU law on free movement and citizenship may help his challenge against both the deportation order and the refusal to include him in the treatment benefits scheme. So we know that this is the Citizenship Directive. Again, I'm not going to go down through this piece by piece, but you would see, has he established any type of rights to citizenship in Ireland, being the 5 years consecutively living here. You would also look at his work conditions, and you would see if there's any possible defences to the deportation and the refusal to accept him onto this treatment benefit scheme. Question, if we go down again, question 5 is a problem question, and we're asked about the freedom of movement of goods. So Article 34, TFEU, quantitative restrictions, and a measure equivalent to quantitative restriction is Article 35. And we go down to all the case law there, Jacksonville, Cassis de Dijon, etc. We talk about the Article 34 being justified because of Article 36. And again, I think that was a fairly easy question. Question 6 was another problem question, so you can just see here it's just a very heavy problem question type exam. If we go down to the very end, it says state aid under Article 107, so we know that the competition law question was a state aid question. If you look at how you would apply the law, actually we'll do that for this question 6. So if you look at my ebook, says that the definition of state aid is support granted by the state or through state resources that favours one or more undertakings. There is a selective advantage. The support distorts or has the potential to distort competition, and it affects trade between EU countries. Then the breach then comes, or the conditions come from Article 107, and they're cumulative, and they say that any aid granted by a state or through the state's resources in any form which distort or threaten to distort competition by favouring certain undertakings or the production of certain goods must be incompatible insofar as it affects trade. Okay, so that's the rule. Let's see what the interpretation of this rule is. So, inability to meet demand doctrine, for example, where the undertaking is unable to cope with demand of regulation, and the conflict of interest doctrine, where an infringement can be identified when the regulation puts the privileged undertaking in a situation of conflict between commercial and regulatory activities. No, so I don't think that is, I don't think those are applicable here. And I don't think there's a dominance piece here either, because we're not dealing with certain undertakings that are dominant in their relevant market. So let's look at other examples of Article 107 in action. So, for example, direct state grants or subsidies such as rescue aid, tax or other social security exemptions, loans at preferential interest rates or indemnities on favourable terms, preferential grants or loans, disposals of land or building at less than full market value, so not at arm's length, debt write-off, waiving of profits or other returns on public funds, export assistance, sweeteners to attract investment into a region, forgiveness of liabilities, for example, employer social security or license payment. These are more akin to what's happening here. So, tax exemption would be the VAT exemption. Subsidy would be the airline passenger subsidy. Interest-free loan would be a forgiveness of interest. So I think, yes, these three measures certainly fall within Article 107 behaviour. But let's see if we can find a justification. So we have state resources being given to an undertaking with a selective advantage, and it has the potential to distort competition if we compare Ireland to the rest of the EU. Let's look at the exemptions. So there's two exceptions to this rule. One is the de minimis rule, provided that the sum does not reach 200,000 euros. So I don't think we can say in any of these examples that the de minimis rule applies. So let's look at the other one, which is the state aid block exemption regulation. And actually, we might be able to find something here that might help us. So examples of the state aid block exemption regulation are culture and heritage conservation, broadband infrastructure, research and development, and regional aid. So whilst this might seem like a regional aid thing, I actually don't think it is. I don't think that the physical attacks on tourists, the hotel rooms being expensive, or the consistently bad weather, I don't think any of those three can fall within the block exemption regulation. Therefore, I would be advising, who's my client here? Yeah, I would be advising the EU Commission that these three proposals are contrary to the state aid rules under Article 108. Then, if the EU Commission believes the proposal is not compatible, the country may not act on the proposed measures until a final decision has been made. So I think you would advise Ireland to halt these measures. If Ireland does go ahead and implement this state aid, the EC must conduct a full and lengthy assessment of the compatibility of the aid with the internal market before it can order the recovery of that aid, regardless of whether the suspension obligation has been breached or not. So yeah, I think the suspension obligation is Article 108. They go ahead anyway, then the consequence of unlawful state aid is, subject to the supervision of the CJAU, the Commission can determine whether the state aid is unlawful. Here we would advise that it is. It can then impose a requirement that the state recovers the aid with interest from the date of the grant. This could result in the organisation being awarded the unlawful state aid suffering severe financial consequences, as by repaying the aid, their cash flow or funds would be significantly reduced. So obviously we don't want Ireland to get to this stage, so we will be advising Ireland not to go ahead with this from the European Commission. That's what I would have said. Also, if you're looking for case law, I've listed them in my ebook. I'm not going to go down through them now, but this has actually happened before in other countries. Okay, question 7 was the case law question, which I never do. Never, ever, ever. And then finally, let me see, Article 8 looks to me like judicial review, locus standi, Article 2634. Very, very nice question. You'll be looking at direct and individual concern, and you will go through all the case law there. Plowman, Commission v France, all that. Yeah, that was a fine question. I think it was a lovely paper actually. The state aid one might have thrown some people if they hadn't prepared it, but actually I think it was a lovely paper. And yeah, that's my breakdown of EU law. I will see you in the next one.